Hi, I'm Greg Dell with attorneys Dell and Schaefer, and I'm here with Cesar Gavidia, and we want to discuss a recent case out of the Federal District Court in Michigan, and this was a case against United of Omaha, also known as Mutual of Omaha as well, if you have a disability insurance policy. It's common for these insurance companies to go under alias names or be incorporated under different names based upon different jurisdictions where they sell policies. But this case in particular was kind of it was a great victory for the claimant, not a case that we handled, but I want to get into the facts with you and give some background here about what happened.
Yep. And Greg, this is a good case. It's called Julia Sun versus United of Omaha Life Insurance Company, and it's out of the Eastern District of Michigan. And it involved Julia Sun, who was a registered nurse and cared for paraplegic patients. Her occupation was considered a medium-level physical demand occupation. And the reason that we bring that up, even though these policies, as we often see, describe the eligibility rules for getting disability as being unable to perform one's regular occupation. That's usually the definition under United of Omaha. And rarely do you see any reference to this medium level occupation or light level occupation. But because of the ERISA laws and ERISA rules, they're allowed to look at it that way, even if that language doesn't appear in the disability policy. So in her case, she had a very physically demanding occupation, obviously. She had to transfer patients, she had to care for them, lift them, she had to care for their medications, the illnesses, the conditions, and all the while these people are paralyzed, they're quadriplegics.
And what was her disabling condition?
Well, she became disabled from an injury that happened to her foot, which ended up developing into plantar fasciitis. And as we know, and we hear, these conditions, they may seem to be kind of benign. You hear people having foot pain or plantar fasciitis, but for her it was worse because she was also dealing with an autoimmune disorder. So there really wasn't too much she could do to treat the problem, and being that she was a nurse, she had to be on her feet the whole time. And she couldn't seek surgery due to the complications from her autoimmune disorder and the medications she was taking due to her autoimmune disorder. And what ended up happening was she had to, her doctors thought that perhaps she could, take some time off and return to work after a period of time, but that never happened. She remained disabled. She actually filed her own disability claim with United of Omaha and was approved and was paid for her own occupation period. Actually, after about a year, they decided to challenge her claim, which we see all the time. She appealed it on her own and actually won her appeal, which is something that doesn't happen too often when an insured does on their own.
But in this particular case, that was before she even had to change a definition from own
So it was about 1 year after she filed for a disability claim.
And they were
already challenging her, right. They did some medical review, and based on that, they just denied her. She appealed it and was successful, but within another year, they denied her again because then she had that occupational definition change from own occupation to any occupation. So basically what that looks like in these United of Omaha policies is going from being unable to perform your regular occupation or the material duties of your regular occupation to being unable to perform any gainful occupation for which you're qualified based on education, training, and experience. And what United of Omaha did at that time when they terminated her claim was they had referred the case to a medical consultant, one of these in-house people that review the medical records. Sometimes it's a nurse, sometimes it's a doctor. It wasn't exactly clear who it was. And actually the court, when they went through their analysis, pointed out that United didn't even mention who this person was in their denial letter. So they obviously had some sort of issue with that, right? And they also did what was called a transferable skills analysis. So they determined based on her education, training, experience, they did this review or analysis by a vocational consultant to determine what occupations could she transfer to based on those education, training, and skills she has. And based on that, they denied her disability claim.
Now, she was approved for Social Security disability as well, right?
Yeah, in that interim, as is often required by these disability policies, and the insurance companies push the insureds to go apply for Social Security disability because it's obviously a financial benefit to the insurance company. They can offset the benefits they pay them by the monthly amount they're getting from Social Security disability. She did that and actually prevailed. So after going through this denial process, filing an administrative appeal with United of Omaha, And being denied again, she'd effectively exhausted all her administrative remedies and had to end up going to court and fighting them in U.S. District Court in Michigan.
And she filed her ERISA lawsuit, and what did the court rule?
So after filing her lawsuit, and having to, and as you know, these cases are reviewed by these federal judges. You don't get a jury trial. In this case, all they did was review the administrative record. And surprisingly, because even though Michigan has a ban on discretionary clauses, as you know,
right,
the court in this case still applied the arbitrary and capricious standard of review. Now, it's not exactly clear why. Maybe that this policy was instated prior to the ban or something, which allows them to continue this arbitrary and capricious standard of review. The court found that that United of Omaha basically didn't have the support in the record to find that she was able to do a sedentary occupation as they said she could do. And on top of that, they actually called United of Omaha out for cherry-picking their vocational consultants' opinions.
And the cherry picking is unfortunately something we see often, where they'll just pick out some kind of line that they think supports their claim, and then they'll use that as the basis for the whole denial. And the reason I find that happens is that you have claims examiners who may not be the most qualified or the most educated in what they're doing.
Right.
So if they find some basis to somehow or another support their denial, they'll just jump on that one or two lines, and they'll either ignore all the other information, which I hope they're not doing intentionally, or they just don't understand the significance of the other findings and how that relates to the person's inability to work.
Yeah, but what was really kind of surprising with this case is the judge pointed out that they were ignoring favorable findings by Sun's doctors, and they were intentionally cherry picking the opinions of their vocational consultant, just to basically put their findings in line with their end result, which was a denial of the benefits.
So that's, they can hide and try to mess with people on certain things, but in this case, the court made a public record of what they did wrong, which is a great victory for this particular claimant. So if you have a claim with Mutual of Omaha or any long-term disability insurance carrier, feel free to give any of our attorneys a call. We're always available for a free consultation, and we look forward to the opportunity to speak with you.